Thank you, Mr. Speaker, and I'm very grateful for the opportunity to have 10 minutes to add some of the concerns that I've had about this bill, which up to this point I've only been able to put forward in questions and comments to others, and I'm grateful that the Liberal Party allowed me one of the slots in their speaking roster this evening. What we've been hearing, and I've been in most of the debates on Bill C-31 since it was tabled, and also in the earlier debates on its predecessor, Bill C-4, what we've been hearing from the Conservatives is that this bill is necessary to end human smuggling. We hear a lot of cries about human smuggling. We hear that people are jumping the queue. We've heard a lot of allegations, and I've structured what I hope to say in the next 10 minutes by mentioning some of the things that are most frequently alleged here and providing some counterbalance to that, because I think that there are egregious parts of this legislation. In fact, I think it violates the Charter and may well be, and future courts will find it to be illegal. Let's just start with one that we hear all the time, the notion that there is queue jumping if refugee claimants come to Canada in some fashion that's different from the way normal immigration occurs to Canada. We must keep very clear in our minds the distinct and large difference between people who come to this country as immigrants, as my parents did, and people who come to this country as political refugees, people fearing for their very lives. In this category, there are no such things as queue jumpers. There is no such a thing as going to line up at an immigration office for Canada in some other country when you know that your life is at risk and you flee with the clothes on your back. So we need to keep these things very separate in our minds, and much of this bill deals with that latter category, people who are seeking refugee status in Canada. Some people can be in fear of their lives when they come to Canada and their refugee claim may be rejected. That does not mean that the adjective bogus applies to their claim. Some people are rejected even though they have a legitimate fear of persecution. They don't make it through our process. Our process, it has been in the past. We'd like to think it's fair and generous, but sometimes it has rejected people who really did need our protection. So let's be clear about that. The vast majority of refugees in this world, and they number in the millions, never make it towards an industrialized country. Most of the migration that occurs in those people who are refugees is from one developing country to another. That's the vast area of claimants. Now, we've heard that this bill, because of its punitive nature towards people who arrive by ship or something other means of arrival deemed an irregular entry, quote-unquote irregular entry is one of the new terms that comes up in Bill C-31. We're told that this punitive treatment of people arriving by ship will discourage so-called human smuggling. I've yet to hear any empirical evidence that that is the case. According to the United Nations High Commissioner on Refugees, and one of their expert analysts, whose name is Alice Edwards, has made a statement. I've taken some time since this bill was first tabled to try to find evidence, and what I've found is the absence of evidence. I want to quote from the finding of the United Nations High Commissioner on Refugees, their expert analyst, who says, quote, "Pragmatically, there is no empirical evidence that the prospect of being detained deters irregular migration or discourages persons from seeking asylum. In fact, the detention of migrants and asylum seekers has increased. In a number of countries, the number of individuals seeking to enter such territories has also risen or remained constant. Globally, migration has been increasing regardless of government policies on detention. Except in specific individual cases, detention is generally an extremely blunt instrument of government policy making on immigration." Let me take you to a letter that was sent to the Prime Minister of this country by a group of people in Australia who've had a lot of experience. Certainly it is true, as the Minister of Immigration said, that other countries are going in a similar direction. It has failed there, it will fail here. This is a letter advising the Prime Minister of Canada not to go in the direction of Australia from the Asylum Seeker Resource Centre in Australia. They refer to the fact that Australia is already learning some hard lessons about trying to discourage refugees by putting people in prison. Australia has abandoned its temporary protection visas because they found that it simply wasn't working. and I will quote from their letter to our Prime Minister, "Contrary to popular belief, tough," and that's in quotes, "tough immigration policies in the past have not succeeded as an effective deterrent. In 1999, less than 1,000 quote-unquote unauthorized arrivals applied for asylum. That was the year in which their temporary protection visa program was introduced. By 2001, when this policy was in full force, the arrivals rose to more than 4,000. Under this policy, denying the right to refugees on temporary protection visas to apply for family reunion pushed the wives and children of asylum seekers onto boats in an attempt to be reunited. In 2001, 353 people drowned in the tragic Seavex disaster while traveling by boat to Australia. Most of the 288 women and children aboard that vessel were family members of TPV holders already in Australia." Close quote. We're also told that this will save money. Bringing in this bill will save money because people will be discouraged from coming here and we won't have our social safety net programs available to refugees. But again, from the experience in Australia, and I've asked several times in this House, and I have yet to have one Conservative member of Parliament offer up a cost of this legislation. As far as I can find, it has not been costed. So we will be having anyone come here by irregular entry, put in detention, men, women, children over 16, and likely minor children as well, because they will opt to stay with a mother rather than be placed far from their families in a foreign land. But let's just see what it's cost Australia. Australia maintains 19 immigration detention facilities. And in the last year in which I could find costs, which was for 2011, they were spending over $668 million on the detention of refugees. And the Australia Secretary in the Department of Immigration and Citizenship remarked, and I don't know when we'll hear this from the Canadian Minister of Citizenship, but, quote, "The cost of long-term detention and the case against the current system are compelling. The cost to the taxpayer of detention is massive, and the debt recovery virtually non-existent." Let me move on to the next thing that we hear in this House. We hear that children will no longer be jailed. Unlike the previous version of this bill, C-4, we're told that the change will allow the children to go somewhere else, we're not told where, while children, and they still are legally children under the international rights of the Convention on the Rights of the Child, 16 to 18-year-olds will be jailed, parents will be jailed, everyone will go to jail for up to a year if they arrive by irregular entry. This is what Australia has started doing, and I'm just going to share the information from the Australian government. They found, and their Commission for Human Rights found, that the detention was actually violating their human rights provisions in Australia and also wasn't working. So in October of 2010, the Australian government changed tact. They've decided that it will begin to move a significant number of families with children into community detention. In other words, they're keeping track of anyone who arrives by irregular entry. They are not essentially integrated into the community in the same way that they would be if they were allowed to work or move around freely. But this community detention process has actually worked to reduce costs. Placement in communities bridges visas and is essentially community detention that requires, similar to parole, that the people involved report to someone, but they actually live in communities. Lastly, we're told, Mr. Speaker, that this bill will deal with people coming from the European Union, and there's no reason anyone should worry about the European Union. Since this bill was tabled, we've had a federal court decision tabled February 22nd, 2012, the case of Hirachi versus Canada. And Mr. Justice Hughes of the federal court said very clearly, quote, "The evidence is overwhelming that Hungary is presently unable to provide adequate protection to its Roma citizens," close quotes. One last court decision to refer to, Mr. Speaker, and that's the Supreme Court of Canada. Charter violations are endemic to this Act. Madam Justice McLaughlin ruled in Charcoot versus Canada 2007 that charter rights extend to foreign nationals. Thank you, Mr. Speaker. We must change this legislation if it's not to violate Canadian values, Canadian law, and the Charter.